Traille Caribbean Limited against Cable and Wireless Jamaica Ltd, trading as line.
Yes, Dr. Barnes.
May it please you, my lords.
We're starting with Lord Burrows only on a single screen, but he assures me there will be no problem.
Fine.
We may have to have a very slight pause when an effective second screen arrives.
As a lordship very. Mr. Wadendale and Miss Traille, Sergio appears with me for the appellant. Learned friend, Miss Penny Skitson, King's Counsel, Mr. Kevin Williams, and Miss Rachel Kitson appear for the respondent. The appellant's case is contained in the submissions which begin at E1510. But as a preliminary submission, may I begin by saying that the appeal principally concerns, firstly, the interpretation of an agreement between the appellant Traille and the respondent Cable and Wireless. And this, your lordship's firmly title refer to them as Traille and CWJ. And that agreement provided for the respondent to supply services to the appellant by way of the transmission of telephone calls brought in from outside of Jamaica to telephone users in Jamaica. And secondly, the interpretation of a ministerial order referred to as the TCT, which imposed a tax on calls brought into Jamaica by the appellant. And those calls are transmitted over the respondent's network to telephone users in Jamaica. And the third issue which arises is what damages, if any, are recoverable by CWJ as a consequence of the grant of an interlocutory injunction for the provision of the interconnection facilities by CWJ to Traille. In view of the limited time, I will stick closer to the written submissions. But may I say at the beginning that in conformity with long-established patterns, public utilities in Jamaica were governed by monopolistic corporations. In the modern era, legislative provisions have been made to encourage fair and free competition. And so that in 1995, a Fair Competition Act was passed, and we have set this out at E1576. And then in 1995, the Offices of Utilities Regulation Act was passed, which established what is generally referred to as the OUR, with the responsibility to monitor and encourage fair and free competition. Now, with the development of new means of telecommunications, the Telecommunications Act was enacted in 2000, and this is at E1749. And this act imposes a duty on every public telecommunications carrier to permit the interconnection with its public network of any other carrier for the provision of telecommunication services. It is in this new dispensation, my lords, that the interconnection agreement with which this appeal is concerned was concluded. And that agreement requires CWJ to allow Traille to interconnect to and with CWJ's system to enable Traille to convey international calls to and from or in transit on their respective systems. And this is explicitly agreed by the parties in their agreed statement of facts and issues, which is at E 1494. I ask you to turn to 151, electronic page number 1511. And paragraph 3 says, in accordance with the agreement, Traille set up interconnection facilities.
Sorry, I've got the wrong reference, I think. I'm looking at...
1511, my lord.
Well, that seems to be an invoice.
And it's paragraph 3?
No.
1511.
1511?
Yeah.
Thank you.
Yes, sir.
Yes, thank you.
In accordance with the agreement, Traille set up interconnection facilities at CWJ's network center in New Kingston, Jamaica, and Traille and CWJ jointly established the necessary apparatus to facilitate the transmission of international telephone calls initiated by Traille and destined for local telephone customers of CWJ or Digicel, another telephone service provider. The agreement provided that CWJ should turn on the switch, permitting Traille to terminate international calls on CWJ's mobile network as soon as Traille provided a bank guarantee to cover early termination charges and paid an initial security deposit of 3 months usage charges. At this point, a dispute arose because CWJ claimed and Traille disagreed that the deposit should include 100% of the newly imposed telephone call tax. On the 1st of May 2014, the OUR expressed the opinion that it is appropriate to include the call tax in the calculation of the initial deposit. On the 23rd of June 2014, CWJ notified Traille that the installation had been completed and the interconnection system was ready for implementation. Traille agreed to comply with the OER's opinion. However, a new dispute then arose as to the calculation of the deposit. CWJ insisted that the 30% exempted taxable call minutes pursuant to paragraph 5B of the order did not apply, and the deposit should include all 100% of the TCT, and Traille disagreed. On the 2nd of July, Traille sought the OER's assistance to resolve this new dispute, but the assistance was not received. CWJ refused to turn on the switch when attempts at conciliation failed to resolve the dispute, and on the 14th of July 2014, Traille filed an action in the Supreme Court claiming inter alia specific performance of the contract by CWJ, damages for breach of contract, and interim relief to compel CWJ to implement the agreement and provide the interconnection. On the 15th of August 2014, Mr. Justice Glenn Brown granted an interlocutory mandatory injunction to Traille on the terms that it should pay the deposit to CWJ, excluding the TCT, and requiring CWJ thereafter to turn on the switch to allow Traille to transmit international calls through its network and order stay for 10 days pending appeal. CWJ appealed to the Court of Appeal against this interlocutory order, and on the 21st of August 2014, the Judge of Appeal Brooks dismissed CWJ's application for further stay of this interlocutory mandatory injunction. CWJ turned on the switch on the 17th of September 2014, and a new dispute then developed between the parties as to which of them should pay the TCT to the tax administration when it fell due each month. My lords, evidence was given detailing the negotiations between the parties, explaining the telecommunication system, describing the conflicting opinions on the application and administration of the telephone's call stacks order, and the measures taken to resolve the disputes. The basic facts were not in dispute and are summarized in both the agreed précis, the statement of facts and issues, which are at pages E1492 to 1505. These are also supplemented by the agreed chronology, which is at E1506. It is therefore, we respectfully submit, surprising that the respondent's submissions should concentrate so much attention on the principle that the board will not reverse concurrent findings of facts made in the courts below. There were concurrent conclusions on the legal significance of certain factual situations or the inferences to be drawn from those factual situations, but there was in fact no important dispute in relation to the facts. So that we submit, therefore, that the principal issues which arise at the very beginning are the interconnection agreement requires the initial security deposit not only to include 3 months estimated service charges, but also 3 months estimated TCT, that is the tax. If the answer to this question is in the negative, then Traille would be entitled to succeed, since CWJ would have had no legal basis on which to refuse the interconnection. But even if the answer to that question is in the affirmative, then since Traille's contention that only 70% of the TCT, if any at all, should be included in the deposit, was upheld by the courts below and has not been challenged by CWJ, and Traille offered to pay this low amount, it follows that CWJ had no legal basis for refusing to turn on the switch, and Traille was therefore entitled to the interlocutory mandatory injunction. There has been no specific finding that the interlocutory injunction was incorrectly obtained. And in fact, the courts below upheld Traille's contention that if the TCT were to be included in the deposit, it would be limited to 70% and not the 100% which CWJ demanded. Accordingly, since Traille was willing to include the 70% of the TCT in the deposit, and CWJ was unwilling to accept that reduced figure, then Traille was entitled to the interlocutory relief, and thereafter CWJ is not entitled to any damages resulting from the grant of that relief.
You never tendered the 70%, did you?
Yes,
You never tendered it.
they offered to pay it, and CWJ expressly said they would not accept it.
But you still didn't tender it.
So that I respectfully submit that if you offer expressly to pay a certain amount, and the opposite party say, I will not accept it, merely sending a check doesn't alter the fact that that party has indicated they will not accept it. And the mechanics of a tender, therefore, I respectfully submit it has no legal significance.
I think the Court of Appeal explicitly said there was no offer made.
No tender, Madam.
No?
No tender.
No, I think
No
the court...
tender, because there is clear evidence of the offer, which I will come to.
Well, I think the Court of Appeal said there was no offer.
Yes, Madam, which is wrong. I submit.
Are you going to come back to all of these points when you've taken us through the highlights? Or
I'm sorry?
are you going to elaborate each of these points?
Yes, Madam.
Yeah.
Contrary to CWJ's submission, the injunctive order did not deal with the provision of the security deposit or the inclusion of the TCT in that deposit. But even if this could be inferred, it certainly did not deal with the issue as to which party had the legal obligation to pay over the TCT to the tax collectorate, as this issue did not arise until after the interlocutory injunction had been granted. And as Mr. Justice Lang pointed out, the parties did not return to the court after this issue arose for any directions. And this is at 1135, paragraph 8 of the judgment. Further, CWJ's claim for damages was not based on the non-payment of the deposit, whether 100% or 70%, but on the payment by Traille of the TCT directly to the tax collectorate rather than to CWJ, so that the losses claimed did not, we respectfully submit, result from the injunction, although it came after the injunction had been granted. So that in respect of the first area of dispute, which relates to the contractual obligations governing the initial security deposit, and these are dealt with in paragraphs 19 to 39 of the written submissions.
Can you give me a page number?
On E1516
Thank you.
and continuing to 1520. And I read paragraphs 19 to 23.
You don't really need to read them out to us, Dr. Barnett. If we have already, of course, read them, but also, if you want to emphasize them, you can ask us to remind ourselves of them by reading them again. It probably saves a bit of time, and I do appreciate you're under quite a bit of time pressure.
Yes, sir. Now, in respect of this matter, my lord, the principal witness for CWJ, Mrs. Simone Winter, stated, and this is at E1024, that no bank guarantee was required by CWJ for early termination charges because under the agreement, one of the things that CWJ could have required of Traille was a bank guarantee covering the first 3 months deposit. But the CWJ said it would not require the bank guarantee, and so this never became an issue, though Traille had offered to provide it. And then she admitted that Traille was willing at all times to pay the deposit less the tax component, and this is at E1033. And then she stated that Traille eventually paid the deposit, excluding the TCT, and this is at E1025. She, however, says no invoice for the deposit was submitted, and this is at E1027. And significantly, she agreed that CWJ should continue to perform the agreement, notwithstanding the dispute about the deposit. And this is at E1028.
I think if you're going to make points on the transcript, you need to take us to the transcript. If you're going to make a particular point,
Yes, sir.
the witness accepted something, I think you need to take us to the relevant passage.
Could I ask you to look at 1033,
Yeah.
line 9
Yes.
to 13.
You need to know that our copy of the transcripts don't include the line numbers, but I know that I've identified the bit you're referring to. At least mine doesn't. But I've got that passage. And then you were going to take us to 1029?
25, 1025.
1025? Yes. Whereabouts there?
And it says, Traille agreed and paid for excluding the tax.
Sorry, I haven't got that. Oh, yes, I put it. Yes, it's the
And then-
second answer.
On page
1025.
1033. And she was asked in the fourth line, you agree that network services he pays for it? Yes, Traille pays the monthly for it. Is he getting anything free from cable and wireless? No. Is it true that claimant was willing to pay at all times the deposit less the tax component? Yes. You refuse to accept that? Yes.
Yeah.
I would therefore respectfully submit that the Court of Appeal erred in failing to take into account that Traille was willing to pay the deposit excluding the TCT and that eventually Traille agreed to pay the deposit inclusive of the TCT, and that the problem arose because CWJ was insisting that the amount to be paid in respect of the TCT was 100%, and Traille was insisting that there was a statutory exemption amounting to 30%. And if you would kind of look at E520, where the Traille stated its position in respect of the 30% exemption. And on page 521, Mrs. Winter, insists on the payment of the PCT at 100% and not at the 70% that Traille said was payable and which the courts below accepted to have been right. Now, insofar as the contractual provisions are concerned, it is our respectful submission that the provisions of the interconnection agreement, which are quoted in paragraphs 19 to 23 of our written submissions on E1516 to 1517. Clearly places the emphasis on the payment of usage charges for services supplied. And not on the payment of taxes.
Well, which sections are you relying on? Which clauses?
On the provisions of clauses 28, 1, 2, and 3 of the agreement, which are the ones cited in paragraph 23 of the submissions. And with the specific reference to the initial deposit, we contend that the provisions of clause 24(4), which is at 314 and is quoted in paragraph 28 of the submissions at page 1518.
24(4).
Yes.
31491.
Yeah. I'm on 314.
Clause 24(4).
24(4).
Yes, sir.
Yeah.
That the mechanism for dealing with disputes relating to failure to keep the security deposit in place required submission of that dispute by the parties after a period of time and not for the termination or non-implementation of the agreement.
Well, how do you get that from 24(4)? 24(4) just says that provided a notice has been served, Lime reserves the right to terminate the agreement if the security deposit isn't provided. How do you get to the requirement to go to dispute resolution?
because in 24(2), which is quoted at paragraph 26, there is a provision to that effect, my Lord.
In what, 24(2)? Sorry, I'm not following this submission. Can you just take me to the clauses and explain where you're getting a requirement to go to dispute resolution from?
Because 24 is saying that if a dispute arises, that the defaulting party, the party who is in default, is in breach of an obligation which is adjudged to be material, has not remedied that breach within 15 days, then a notice has to be served requiring that it be remedied.
But we're on 24(4), which is the clause dealing specifically with security deposits.
And we are saying that that clause was not invoked by CWG.
Why not?
Because they would have had to give a notice specifying that you have 14 days in which to comply, or 7 days in which to comply. But in any event, my Lord, we are saying that, and this has been upheld in the judgments below, that in any event, CWJ was demanding the wrong amount, and therefore was not in a position to terminate the agreement when it refused to accept the right amount. And as we point out in paragraph 30 of the submissions, the agreement came into effect on signing, and therefore the turning on of the switch is part of the compliance with the agreement. And CWJ was therefore in breach in refusing to turn on the switch on the basis that the deposit should include 100% of the PCT.
Sorry, can I just come back to this dispute resolution? Are you saying that clause 36, is that part of your submissions?
Because if there is a dispute, there are in the agreement provisions for a resolution of the dispute. And that was an alternative which could have been, which was available and ought to have been resorted to. Because it was a case in which the dispute concerned the construction of the TCT, over which both parties agreed that there were uncertainties. And in that state of affairs, it seems that it is reasonable that the dispute resolution alternatives should have been resorted to.
But I thought they did go to the regulator. They went to the OUR.
They did go to the OUR eventually, and the OUR indicated that the deposit should include the TCT, which, as your Lordship will recall, I had indicated that Traille agreed to accept that determination by the OUR, but the problem was that when it came to how much should be included, CWJ insisted on 100%, which was wrong, and refused to accept 70%.
So the first principal issue that you put forward to us, you're no longer maintaining that. Because the first submission you put forward was that there were TCT should not have been included in the deposit. But you're now saying that your client accepted the OUR decision.
Yes, my Lord, because we're saying as a matter of law, we were right.
So the submission is now, we're now on submission 2, are we, of the
It's the alternative.
Yeah, so we're talking now about the 70% point.
Indeed, my Lord. But it's not that I abandon it, it's that I'm saying that in any event, Traille is in a good position because it agreed to accept that 70% should be paid and agreed to pay 70%, but CWJ would not accept 70%.
You haven't got any findings to that effect, have you?
I'm sorry, my Lord?
There are no findings by the judge or the court to that effect?
That
you agreed to accept?
I think, yes, my Lord, I think the finding of the court was that we agreed to accept, but in any event, this is an agreed fact by the parties. And the problem was not the acceptance of the responsibility or the liability to include TCT in the deposit. The problem was that when Traille agreed that it would accept the OUR's determination that it should be included, the issue in relation to the 70% arose, and CWJ made it very clear that it would not accept 70%.
Well, when you say it's an agreed fact, what do you mean? You said it's an agreed fact between the parties.
Yes, sir.
What's the agreed fact?
The agreed fact is that Traille indicated its willingness to pay the deposits inclusive of the TCT up to 70%.
Can you show us where that agreed fact is stated?
Is this paragraph 6 at 1495? Which you'll know.
If you look at 1507, my Lord.
I see. It's in there.
And this is an agreed chronology. This gives the sequence in which this occurred. Item 14, and the reference is given at 522, but item 14 summarizes it. Traille agreed to comply with the OUR determination.
Well, that's not the 70% issue.
Yeah.
That is that the TCT should be included.
Yes.
But the 70% issue was not determined at that time by the OER.
No, so where is the agreed fact that they were willing to pay up to 70%?
If you look at page 522,
522.
What page?
you'll see that Lamb was writing to,
522.
Traille was writing to Mrs. Cummings of CWJ. To OUR. It is not accepted that OUR, having ruled that Lamb must pay the calls tax, and Traille agrees to comply with that ruling, that we are not able to complete connectivity. We have shown Lamb that their calculation of the special deposit on the calls tax, as per technical notes, as per gazetted law, we have emailed and called and cannot get a corrected figure in order to pay our special deposit. We find this unacceptable, and it is written very plain in all reference documents that exemption 5B in respect of 30% of all taxable minutes in each transaction month for each call category. And so then these are the calculation. It worries me that Lamb would want to request from Traille to pay 0.75 per minute and pay over to the Commissioner 0.525. This will be the net result of the 30% exemption.
So who is Mrs. Cummings?
That is, she's an officer of the OUR.
Yes.
I see. So,
And in paragraph 67 of our submissions,
I'm looking for
at 1528, we summarize the position in relation to the 30% discount. A critical factor is that CWJ insisted that the 30% discounted rate on the TCT with Traille claim was not applicable, but were held to be in error in this respect. Traille had clearly indicated its willingness to pay the deposit plus the TCT with the 30% discount, as indicated by email of the 1st of July 2014 from Rory Robinson to Simone Winto. This is at 1081. Following up on his email of 30th June, requesting the recalculated figure with TCT limited to 70%. See also the affidavit of Rory Robinson at 1076-77 and witness statement of Simone Winto, CWJ's witness. CWJ, however, made it clear that it would not activate the interconnection unless 100% of the estimated TCT was paid. See the statement of facts and issues at paragraphs 4 and 25.9 at 1082.
I think the difficulty is that I don't think there's any agreed fact about this, as I understand it. This is your interpretation of an email or a couple of emails at page 1081.
Yes.
And I think the problem that you might regard as having is that at least the Court of Appeal didn't see it in quite that way. You might have been asking what it is that is now being asked for, but it doesn't indicate that the next step taken was and we are willing now to pay that full amount, and clearly that doesn't amount to a tender either. But is that it? Are they the emails on 1081 following on 1080? That is what you rest your submission on, is it?
My submission rests on the fact that the exchange of emails between 1080 and 1084 is only consistent with Traille offering to pay the deposit inclusive of the tax, but only to the extent of 70%, and CWJ refusing that offer on the basis that 100% of the TCT should be included. I respectfully submit there is no doubt that that was the position taken by the parties at that time.
Well, if you go to the Court of Appeal at 1213,
Right. Here's the signature. Yes, my lord. The Court of Appeal said, strictly speaking, there was no offer.
yeah, because they interpret it rather differently than you do.
Yes, I did. But I would respectfully submit, my lord, that the correspondence is very clear as to Traille's willingness to pay the TCT up to 70% as part of the deposit, and CWJ's refusal to accept that amount.
And would you say that amounts to are you going so far as to say it amounts to a tender?
I would say it's a tender, my lord, but I do not want to base my submission on a technical, verbalistic term. The position between the contracting parties is that one contracting party says, I'm willing to pay this, and the other contracting party says, I will not accept that. What is this issue? This is issue, not agreement. And your lordship is correct that this issue was put before the Court of Appeal, and if you look at 1500, page 1500, number 9, CWJ was demanding the payment of 100% rather than 70% of the TCT, and would in any event have refused to provide the interconnection. For CWJ not acting in breach of the agreement, so as to be disentitled to obtain damages because it was required by the injunction to comply with its contractual obligations. So that issue was put to the Court of Appeal, but the clear assumption of that issue is that CWJ was demanding 100% of the TCT and refusing to accept 70%. And at page 1495, my lord, you'll see that
Yes, I'm not sure whether it's just ground 9 or a mix of perhaps ground 8 and ground 9. But anyway, yeah. I think the Court of Appeal saw it as part of ground 8, actually. Paragraph 71 on page 1210.
Yes. Ground 9 appears to be more to do with what happened after the injunction was granted.
yes,
And whether there's an entitlement to damages under the cross undertaking than whether there was a tender of the 7% tax element of the deposit.
I submit that, my lord, there is no doubt whatsoever that the position after the OUR's opinion was received was, as stated in the agreed statement of facts, paragraph 6 on page 1495, that Traille agreed to comply with the OUR's determination and that a new dispute arose as to the calculation of the deposit. CWJ insisted the deposit should include the 30% exempted taxable call minutes pursuant to paragraph 5B of the order referred to below in paragraph 8, and Traille disagreed. So that was the basis on which the conflict.
Well, I don't think that, I accept that's not in dispute.
Yes, sir.
The dispute is whether your clients, were offering or tendering 70%.
I respectfully submit there is no dispute as to that because of what I've shown already, that they wrote saying, we are willing to pay this, recalculate your invoice. And CWJ said, we will not be accepting less than 100%. I respectfully submit that there is no doubt that...
But there was a finding by the judge and the Court of Appeal that you didn't tender.
Yes, and I respectfully submit that the finding is based on a technical approach to tender. It is saying that unless you actually send the money, then you would not have sufficiently indicated your acceptance of the obligation.
Well, it's not merely sending the money, it's making clear that you are going to send this amount of money.
Yes, but that's indicated in the emails.
Well, as I say, that's your interpretation of it, but it's not one that the Court of Appeal agreed with.
But I ask your lordship to look at those emails and see if there's any other reasonable interpretation.
Yeah. You say the interpretation is obvious.
Yes, my lord.
Thank you.
Mr. Barnett, we started all this on page 1517.
I'm sorry, Lord.
Clause 28.2 of the connection agreement. In the context of your primary submission, usage charges didn't include the tax anyway, although the OUR advised otherwise. Can you remind me, my recollection being that usage charges in clause 28.2 is a defined term, where we find the definition of usage charges?
In the agreement itself, which is at 316.
316, did you say?
I think my lord is asking for the page where usage charges is defined, and that is at page 494.
Thank you. Yeah.
But there is a provision, my lord, in the agreement which deals with charges, and this is at page 442. To 443. Which shows quite clearly what usage charges comprise, but the issue is whether under the interconnection agreement the usage charges should be expanded beyond that definition to include the TCT on the basis that it is an applicable tax. And the submission that we make is that the TCT is a very special tax which cannot readily or at all fit into the phrase applicable tax, because clearly the agreement did not intend that all tax payable by the parties should be included as service charges. And therefore, we submit that the TCT, which is a very special tax, did not fall into that category where it should be included in service charges.
So are you taking us to clause 9.7? Is that what we're looking at when you use the phrase applicable tax?
Yes, my lord.
Your submission is that that doesn't include
The TCT.
TCT. But if it were an applicable tax, are you accepting that that provision would apply to allow the addition of the taxes to the service charge?
Yes, ma'am, to the deposit and the service.
To the deposit, yes.
Yeah. But as I say, because the OER's opinion on that was accepted, in the end it resulted in insofar as the deposit itself is concerned, that the parties were in agreement that the deposit should include the TCT, and the real issue was whether it should be 100% or 70%.
Yeah. Do you think that clause 36, the dispute resolution, were you bound to accept the resolution by the OUR?
No, my lord, but as I say, it didn't matter on this particular issue because of the fact that Traille agreed to accept it.
Right, but you don't consider that you were bound?
No, my lord, you don't consider
No.
Because they went beyond what was asked them at that stage to deal with the second issue, which had not yet arisen, and to express an opinion that the tax was to be paid directly, the payment should be made by CWG and not directly by Traille.
But I think you've already made the point, and we went through this earlier, that the first of the highlighted issues that you were setting out for us, it doesn't sound as if you're really pushing that point, because you're accepting that tax was an appropriate, that could be added to the service to the user charge.
I put it somewhat differently, my lord. I say that it became immaterial because of the acceptance. But at subsequent stages, if it is material, then I'm not making a concession.
Well, what subsequent check? Why could it become material?
I don't think it became material because the subsequent issue related to who should pay the tax and not the amount of the tax. Yeah. The subsequent issue related to who should pay the tax over to the tax collectorate and not the amount of the tax.
Yeah.
So that it didn't really have an impact on the subsequent.
So we can put that out of our heads, can we?
Yes, sir.
Well, I'm sorry. I really do wish to clarify this. But could I ask you, please, to look at your list of principal issues, which you let us have yesterday?
Yes, sir.
And as I understand it, you did address us on the first of those principal issues. Have you got the document there?
Yes, sir.
Now, you've been addressing us in the last half hour or so on the second issue. But
yes, that's
could
correct.
I ask you, please, absolutely clearly,
yes,
in relation to the first issue, are you abandoning that point?
No, I'm not abandoning it, my lord, but I'm saying that its importance has receded.
I understand that. Thank you.
Your Lordship would have seen that an important question was whether or not the statutory provisions place the obligation on Traille or CWG to make the monthly payments of the tax. And at page 1520, we begin to set out our submissions in respect of that issue. And we have indicated the nature of the TCT and that it was not analogous to the GCT. The GCT in Jamaica is imposed by the General Consumption Tax Act, which is a value-added tax, similar to that in the UK. And the GCT is a tax which is imposed on the persons who receive goods or services and has to be collected by the supplier of the goods or services on an invoice which is given to the receiver of the goods or services. Whereas the TCT is not imposed on the recipients of the calls or the makers of the calls, but is a tax of a completely different nature, which is based on the number of minutes used, and a straight calculation of the payable tax by multiplying the rate by the number of minutes used and having nothing to do with value. And in the submissions, we have made that distinction. And so we say that in paragraph 43, which is on page 1521, having pointed out the distinction between GCT and TCT, that Traille brought international calls into Jamaica and engaged CWD to transmit them to mobile phones of the recipients of those calls. As a person who was bringing calls from abroad for termination in Jamaica, Traille was responsible for paying to TCT directly to the tax administration. By contrast, Traille, in paying the service charges to CWD for the interconnection service it provided, had to pay the GCT on those service charges to CWD, which had the responsibility to pay it over to the tax administration. And there was evidence in relation to this and what the parties' approach was, and give you the references, my lord, at page 113 and 233. But there are additional references at page 521 and 805, paragraph 4. And we say that according to the Court of Appeal and Mr. Justice Batts at first instance, heard in...
Sorry, I'm awfully sorry to interrupt you. Could you just give me those page references again that you gave us a moment ago?
The pages are 113.
113.
And it's paragraphs 11 and 12 on that page.
113.
113.
And 233 to 4.
233 to 4.
Paragraph 7. Page 521. And page 805, paragraph 4.
Thank you. Yeah.
My lord, at paragraph 45 on page 1522, we make reference to the validity of the TCT order, but that was raised not as a challenge to its validity, but as an indication that, as the parties themselves said, the whole matter of the TCT was a matter of doubt and dispute and uncertainty. And this is another illustration of the fact that the parties were grappling with a new tax, which was not properly understood, and therefore the action of a party based on its interpretation in that situation of doubt could not be treated as a repudiatory breach, as they were genuinely trying to sort out the technical difficulties that they were encountering. And we were not raising a constitutional question as to the validity of the Validation Act, which was passed years after to validate the illegality which had existed over years. But just to point out that the matters were in genuine dispute and therefore should not be treated as a repudiatory breach, entitling CWG to say that it will not implement the agreement. Now, on the question, however, of whether or not the TCT is to be treated as a tax similar to the general consumption tax, and therefore that Traille was to pay the TCT to CWG, who would then pay it over to the tax collectorate. We submit that on that issue, it is clear that the proper interpretation of the TCT order is that that obligation fell on Traille. This was examined in the courts below, and the various provisions are dealt with in paragraph 47 on page 1522 to 1523, paragraph 50, and in paragraph 50 we say it was accepted by both parties that Traille would be transmitting international calls to CWJ's network in Jamaica. And we cite in support of that the email of the 2nd of July, which is at page 521, and the questions and answers in cross-examination of Traille's witness, Roy Robinson, at pages 999 and 1000. So that an issue arose, as we have already noted, as to who is the applicable taxpayer. And the TC order, which is at 281, provides that the applicable taxpayer means a carrier or a service provider who is registered pursuant to Section 27 of the JCT Act and is liable to pay tax under the TCT order.
Sorry, what page are you on?
This is at, I'm really amplifying paragraph on page 1523.
Oh,
I think you took us to page 281.
yes. That's what I thought you
Terminating
said.
carrier means a carrier who provides termination services on its public network.
Yes, my lord, and
That's the technical note, isn't it?
It is.
Not the order.
Yes.
I mean, it may not matter, but to be precise, that's the technical note.
my lord, the quotation, the use of the word on its public network has to be seen in the context that
Well,
the Telecommunications Act and the agreement which was made under the provisions of the Telecommunications Act provided that a person in the business of providing telephone services was entitled to seek interconnection facilities from another provider in order to deliver calls.
Well, I'm looking at the section starting person liable to tax on page 281, which is in the technical note before we get to the order itself. Where it says that tax is to be paid by a terminating carrier in the case of international incoming calls, which is what we're here concerned with, I think. And terminating carrier means a carrier who provides termination services on its public network, which appears to assume that in order to be the taxpayer, you've got to have a public network in Jamaica.
Yeah, Your Lordship is referring to the technical note.
Yes,
Yes,
absolutely.
which is,
But that you took us to page 281.
yeah,
and
yes,
that's the bit
my
that
lord, yeah.
seemed to be relevant.
And this is very important because the technical note was used as the basis for the decision of the Court of Appeal, because when the statutory provisions were examined, their lordships concluded that the statutory provisions applied equally to Traille and CWG. But the turning point was the reliance on the technical note.
Yes.
But we submit that,
Can you just show us would you mind giving us the reference in the Court of Appeal judgment to where they deal with this? Because they disagreed, therefore, with the first instance judge on this point.
this is on page 1199.
1199.
Yes.
I mean, it's
Yes, my lord. So that the decisive factor in the reasoning of the Court of Appeal was the statement in the technical note.
well. I mean, so at page 1199, at paragraph 45, the Court of Appeal refers to the relevant statutory provision,
Yes, my lord.
which is Section 3 of the TCT order,
Yeah.
which imposes the tax on an applicable taxpayer, and then they've highlighted the relevant words, who provides telephone service in Jamaica.
Yes, my lord.
And then they refer,
But at that point, my lord, that you will notice at the end of paragraph 46
I see,
on page 1201,
provides,
the Court of Appeal, having examined the statutory provisions, says there's therefore so far still nothing to distinguish between Traille and CWG as to which is eliminated as the party responsible for paying over the TCT to tax administration.
yes, I see.
So that,
So they arrived at the same result at as the first instance judge, Mr. Justice Batts, but he did it without regard to the technical note. He said
Yes,
he
ma'am.
shouldn't look at it.
yes,
And the Court of Appeal did it by reference to the technical note.
because inferentially they are saying that Mr. Justice Batts' construction of the statutory provisions was not correct, because he had treated the statutory provisions as making a distinction between Traille and CWG.
Yes.
And the Court of Appeal is saying the statutory provisions do not make a distinction between those two parties as to who is responsible for paying. But they then go on to treat the technical note as decisive.
Yes.
Could you just refer us to the paragraphs of Mr. Justice Batts' decision where he deals with this point?
I will, as soon as I can, bring it over. Meanwhile, go on.
Sorry?
They're go on in the meanwhile while I have that is.
Oh, yes, certainly.
So that it is important, therefore, to examine the technical note.
I see.
And the technical note at 285.
We've got little c, and there's another relevant passage, isn't there, at the top of 284, payment of taxes, paragraph A.
It begins on page 879. On page 281,
Yeah.
it says, under the heading personal liable to tax, it says terminating carrier means a carrier who provides termination service on its public network.
Yeah.
And then,
I mean, is it common ground that Cable and Wireless does have and Traille doesn't have
Yes,
a
ma'am.
public network in Jamaica?
but I ask you now to contrast that with the provisions of the tax order itself, which is at page, begins on page 288, which imposes the tax and there's Subject to provision of this order, every applicable taxpayer who provides telephone service in Jamaica shall pay to the Commissioner General a tax on telephone calls, herein referred to as a tax on provided. And as we go to C, from a point originating outside of Jamaica, which was the situation in respect of the relevant calls, and terminating on a public mobile network in Jamaica. So that the statutory provision itself does not state its own public mobile network. Your Lordship had asked for the treatment of the matter by Mr. Justice Batts.
I'm so sorry, page?
And it starts on page 1060.
1060.
Paragraph 48. And His Lordship did not deal with any detailed examination of the statutory provision, but goes on, having quoted the section, to deal with the evidence, and says that the evidence is clear that the defendant is the terminating carrier. But our submission is that the agreement between Traille and CWJ provided that CWJ would provide a service to Traille for the termination of calls brought in from outside of Jamaica and destined for telephones in Jamaica. And it was Traille that had the principal responsibility for providing that service to the customers who had contracted that service. And we submit that the technical note is inconsistent with the language of the statutory provision by changing from a public network to its public network. We further submit that it is important to take into account that the ministry paper, which is at page 274,
just before we leave the technical note, is it your further submission that it's not something we should be looking at? Or are you saying, well, it would have been fine had it been consistent with the regulation? It would have been fine to look at it.
The language of the regulation, my Lord. That is my submission. That you can look at technical notes if there is a technical issue which arises as to what the statutory provision means. And we have taken an extract from Craze, which your Lordship will notice that we have cited. But you cannot use the technical note to alter the language of the statute.
Can you just give us the reference to the technical note again, please? Sorry.
The technical note, reference to the technical note.
You did take us to it, but
281.
281. Thank you very much.
Yes.
So,
There are actually two versions because there was a revision, but one is a 279, but this 281 the passage we are quoting in 281 is in the second version.
Right, thank you.
And I was about to refer, my lords, to the ministry paper.
I mean, the technical note was published a year after the order, I think.
Yes, my lord. And it's not the document which was in the parliamentary committee which approved the legislation. It was the comment afterwards or observations afterwards by technical officers of the ministry. And I wish to point out specifically that when the correspondence began in relation to how the order should be interpreted, the same ministry said that it was not clear to them. And I ask your lordship, in respect of that submission, to look at page 519. Where the very taxation policy division of the ministry responsible for the imposition of the taxes, when asked for clarification by Traille, says the request initially submitted to our technical specialist for review, but based on the nuances of the case, our legal advisors have been asked to provide an opinion on the way forward, so that the administration that had prepared the technical note is now admitting that it is not clear. And they had consulted with the tax specialists. Yes. Yeah. 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 Let you know. Yeah. Could I just make one correction in relation to the sequence of events? The technical note is dated the 19th of July 2012. This is at page 279. And the order is dated the 30th of August 2012. This is at page 288.
So it's July, I see.
Sorry, so
So it came before.
it came marginally before.
That's what I thought.
I see.
Yes, my lord.
Yeah.
The first version of the technical note came before the order.
Both, my lord.
I
Both.
see.
Both.
Right.
But both came.
Both the technical note.
I see.
Right, thank you.
And would you accept, Dr. Barney, that however one construes the order, its framers must be taken to have identified a single taxpayer in relation to a series of incoming calls rather than two? I mean, it's very odd if two different people are liable to pay the tax on the same incoming calls.
They sought to do that, my lord, but what the submission I'm making is that they did that by a alteration of the language of the order.
Of course.
Yeah.
But my question to you is, are we looking, when trying to understand what the order means, for a single taxpayer or possibly a whole row of paragraphs?
Yes, my lord, I think we should. And in answer to that, may I say that you begin with who has the liability to pay the tax.
That
in
must
order
be
to
some-
shift that burden.
But in relation to a stream of incoming international calls, that must be one person. If there are more than one person involved in the process, it must be one rather than two, mustn't it?
I entirely agree, my lord, and I say that is Traille.
No, I understand you say it's Traille. I'm just wanting to make sure we're agreed that when we put on our interpretation
Yes, sir.
spectacles, we're looking for one rather than possibly two parallel taxpayers.
Yes, my lord, definitely. Yeah. And I was about to refer to the ministry paper, my lord, which is at page 274. See if you find my Bible. And that was what was presented to Parliament by the Minister of Finance with the responsibility for the putting forward of the proposals for the government's tax measures. And you will see that in that ministry paper,
Where would you like us to go in particular?
on page 275,
Yeah.
it speaks of, it is proposed that the tax be levied as follows.
Oh, where? Oh, yes.
Paragraph 5B,
275, you know?
I think.
Yeah.
And
Yeah.
5B, it is proposed that the tax be levied as follows, and the relevant one is 3, Roman 3, 0.75 per minute be imposed on international calls terminating on a mobile network in Jamaica. And then on page 276,
276. Yeah.
in E of that same paragraph 5, the tax will therefore be imposed as follows. On all domestic and international call minutes originating from the public switch network and public LAN network subject to the aforementioned exemptions. I'm sorry, I should have read 1. On all international call minutes which terminates on the public LAN mobile network.
Yeah. This isn't about who pays the tax, is it? It's just identifying what electronic activity in terms of calls
Yes, sir.
trigger the tax.
But it says it is dealing with how the tax is imposed, and it doesn't suggest, and in fact is inconsistent with the suggestion that the tax is limited. The imposition of the tax or the liability to pay the tax is dictated by the phrase, its own network.
This is silent as to who has to pay the tax, isn't it? This document.
Or who has to pay it over. Yeah.
It's silent as to who has to account to the revenue for the tax. So far as I read it, I can't see anything in it that tells you who is the taxpayer. It tells you what triggers the tax, what brings revenue into the Jamaican public revenue. It doesn't tell you who has to pay it. Tell me if I'm wrong, because if there's anything in here that does tell you who has to pay the tax, obviously maybe highly relevant.
Yes, my lord, I accept that, but what it doesn't say is that it is qualified by its own network, which is the qualification that the technical note
It's not talking about who
introduced.
the taxpayer is.
Yeah. So that I respectfully submit, therefore, that one has to come back to an examination of the order itself. And in that respect, I say that the essential factor is that the liability to pay the tax fell on Traille.
I mean, the essential point is, if one just looks at the order itself, whether Traille, quote, provided telephone services in Jamaica.
Yes, sir. And our submission in response to that is that it contracted to provide telephone services in Jamaica by bringing in the calls and having a contract with CWD for the delivery of those calls to specified persons.
I think what Mr. Justice Batts concluded was that if you read the whole of Section 3, that's including paragraphs A, B, and C, then the expression "who provides telephone service in Jamaica" equates to someone operating a network in Jamaica.
Yeah, which I respectfully submit is clearly wrong, and the Court of Appeal did not agree with that.
They arrived at the same result by looking at the
Yes.
technical note.
Yes, yes, which is not a construction which I
mean, they said there was no
correct.
inconsistency
Yes.
between the notes.
Yes.
So
We're
that,
getting within 10 minutes of your time, Doctor.
I'm sorry?
We're getting within 10 minutes of your time.
Yes.
I think so.
I have not,
Perhaps ought to leave
this
you
is
to-
the, as your Lordship clearly appreciate, this is the central problem of the case. The remaining matters dealt with the damages, and our essential submission on that is that the injunction required the interconnection to be activated. And as CWJ itself admitted, the delay in the activation of the switch was resulting in loss of money, not only by Traille, but by CWJ itself. So the injunction really facilitated an expansion of both parties' business, and the real damages claimed are losses which resulted from the payment by CWD of the false tax to the tax collectorate, while Traille was making payments of the same tax to the tax collectorate. And we have set out in our submissions the reason why, on a proper application of the principles relating to damages resulting from an interlocutory injunction, it cannot be said that the injunction caused those losses.
I think you also made a pleading point about interest.
Yes, my Lord, we did.
And I wasn't quite sure I followed that, because one wouldn't, unless I'm mistaken, have normal pleadings, would you, in relation to an inquiry as to damages in relation to a cross-undertaking in damages? I don't think one has pleadings, does one?
No, there would not be any pleadings in that sense, but there would have, well, I haven't dealt with this, but you'll also recall that Appellant Wireless did file a counterclaim, which was dismissed. And in respect of the claim for damages, I submit that whilst ordinary pleadings would not be relevant or the test, it is in accordance with principles of fairness and the modern civil procedure codes that any important claim should be notified. And since no prior notice was given in relation to it, we submit that the principle nevertheless applies. And so in order I adopt the written submissions, which of course in the limited time is not possible to go through in detail, but do ask you to consider them.
Yes, we have already.
May it please the Honour.
Well, thank you very much. You do have 5 more minutes if you want them, Dr. Barnett. But of course you don't have to use all your time if you've said everything you want to say.
Yeah. There's also an issue which we had raised in our submissions, my Lord, about net benefit, which there are lots of decisions which speak to that point.
Yeah.
You'll recall that early in my submissions I had indicated that CWJ had stated that the delay in the implementation of the agreement, or rather in the turning on of the switch, because of the dispute about the deposit, was resulting in loss by them as well as Traille. And there is also the fact that Traille's raising of the issue of the 30% exemption was to CWJ's immense benefit, because they also became entitled to apply the 30% discount.
But in fact, they accounted for 100%, didn't they?
I'm sorry, no?
They accounted for 100% of the tax.
They had been paying 100%.
But they went on paying 100% under the operation of the agreement following the injunction.
Yes, that's right.
Yeah.
And they were able to set off the excess payments, which for them amounted to many, many millions of dollars.
So you say, as a result of all this litigation, they actually end up discovering something about the law that they wouldn't otherwise have discovered. That is, that they only have to pay 70% and not 100%.
Substantial benefit. And remarkably, they resisted it at first.
Yeah.
Yeah. And so that they were getting income from us, they were getting a rebate on the taxes they had been paying and a refund, so that to say that they suffered as a result of the injunction is, with respect, not sustainable. May it please Your Honor.
Thank you. Yes, Ms. Kitson.
May it please, my lords. If I might start where my learned friend left off, which is on the issue of who is the applicable taxpayer. And my lord, as we had just seen...
Ms. Kitson, it may be that the technical people who are making sure that we have a good, clear, live broadcast would want you to be able to be, as it were, in front of both your microphones. I'm not suggesting your junior should be shoved out of the bench, but you may want to slide your desk sideways a bit.
Very well, my lords. Thank you. my Lord Batts had a very detailed, I would say, analysis of the provisions of the order to determine who was the applicable taxpayer. And he starts doing so at paragraph 45 of his judgment, 10.5.8. And what he does, my lords, is that he looks at the definition of applicable taxpayer as found in the Gazette. And I believe we had just looked at this when we saw that he determined that the applicable taxpayer means a carrier or service provider who is registered pursuant to Section 27 of the General Consumption Tax Act and is liable to pay tax under this order. He then goes on to recognize that the provision in the statute, Section 3, sub C, refers to someone who is providing this service from a point originating outside of Jamaica and terminating on a mobile network in Jamaica. And that must be someone who provides a telephone service in Jamaica. My lords, both witnesses for the appellant admitted that they do not provide a telephone service in Jamaica. And if I can take you to the notes of evidence, first, page 1009, where the witness was asked, this is Mr. Robinson, and in fact this is after a lengthy discourse on the provisions of the statute. On 1009, just as I would go to Flow for Business, do you not provide that to the public, offer internet service to the public? No. No domestic telephone service to the public? No. The only thing I do is carrier service for international telephone service to Jamaica. Question, no telephone service in Jamaica? No. I have the license to do it, but I don't want to. That's Mr. Robinson. If we go now, my lords, to Mr. Chatou, Mr. Chatou's evidence on this issue can be found at 10.1.3. Question. The facility that Traille operates is one that brings in overseas incoming traffic to be interconnected to cable and wireless? Yes, and transmit to Digicel. Nothing else? No. No telephone call service in Jamaica? To Jamaica? No, not at this moment. So, my lord, when my Lord Batts concluded, as he did in his judgment, after going through all of this, my lords, on page 1058 to 1059, he then concludes, my lord, that Traille does not provide a telephone service in Jamaica. That is on page 1059 at the bottom of paragraph 46. The words of importance here are, who provides telephone service in Jamaica? The defendant argues, and I agree, that the claimant does not provide a telephone service in Jamaica. So, my lord, in those circumstances, the appellant could not be the applicable taxpayer. He then goes on, my lords, in paragraph 49, to say the evidence is clear that the defendant is the terminating carrier. And in coming to that conclusion, my lord, Bax was drawn to the provisions of the interconnection agreement between the parties, which indicates that Cable and Wireless was providing termination services, and that Traille was the service taker.
Save in relation to Digicel.
Sorry, thank you, my lord. Save in relation to Digicel, in which case it transited those calls from its network to Digicel's network. So, in fact, there were two services. There was a transit service, and there was a terminating service. So, calls which were intended to go on Cable and Wireless network were terminated on that network, and calls that were intended to transit Cable and Wireless's network, which the evidence shows was 90% of those calls, were
terminating for these purposes means ending up on that network.
ending up on the network, my lord.
So going to a recipient,
To get to the eventual recipient of the call. So in this case, where 90% of those calls were going to Digicel, Cable and Wireless was forced to pay invoices which Digicel tendered to Cable and Wireless for those calls.
So does the judge make a finding about the proportion going to Digicel?
I believe so, my lord. I'm going to have my junior look for that. Well,
But your submission is in any
Evidence
event,
was.
in relation to those which were terminating on the Cable and Wireless Jamaica
Yes, my
network.
in relation to those which were terminating on Cable and Wireless network, Cable and Wireless was obliged to pay the tax authorities the tax within 30 days of the call being landed. And then Cable and Wireless issues an invoice to the sender of the calls and expects to be paid what it has charged and expects to be paid the tax that it has advanced.
And similarly, for calls terminating at Digicel, they pay the tax and invoice Cable and Wireless, who invoice
Absolutely, my lord.
down the line. So,
That is exactly what happened.
so you say, in the end, it works quite like VAT.
It works exactly like the VAT.
As I see it, there's no statutory obligation on anybody below the owner of the public network on whose network the calls terminate to pay any tax at all.
Well, my lord,
It appears that the tax that obligation isn't, as it would be under VAT, a statutory obligation. It just appears to be, if anything, a contractual obligation.
it certainly is also a contractual obligation, my lord. And
That's what's relied on here, as I understand it. It's the reliance on the contractual obligation alone
Yes.
that is so. And so
has been your case.
Yes.
Cable and Wireless, in its interconnection agreement, which I hasten to remind the court, is a reference interconnection offer approved by the OUR for the purpose of contracting with parties. That agreement at clause 9.7 made it clear that applicable taxes would be included in the charges and obviously in the deposit imposed. And so, my lords, this takes me quickly to the other issue that I think my learned friends had raised in the summary that I got yesterday. In that summary, my lords, in items 1 and 2, the issue that I heard my learned friend say, Dr. Barnett say, was that the importance of question 1 had receded as he went to court, and the issue of the 70%, or who was to pay the tax, was an issue that arose long after. I believe Dr. Barnett's submission is that the issue as to who was to pay the tax was a new issue which arose, he says, after the injunction was granted. In fact, I believe that the submission is at the note at the end of that summary. On the 7th of November 2014, after the grant of the interlocutory injunction, a new dispute arose as to which party had the responsibility to pay the tax.
Oh, I see.
No, we disagree with that, my lord. And we disagree with that particularly because when you look at the correspondence that obtained in April of 2014 between Mr. Robinson and the OUR, Cable and Wireless and the OUR in response, it is plain that it is not only the question of whether the tax is included in the deposit, but who is to pay the tax. And my lords, I would want to take you then to the correspondence that my learned friend had referred to earlier, those letters that passed between Mr. Robinson to Ms. Cummings at the OUR and the respondent and the respondent's response to that. And those, may it please you, are at EB 512. EB 512 is actually the response by Cable and Wireless to the letter written by Mr. Robinson. EB 512, my lords. I believe Mr. Robinson's letter is at EB 510. And in that 510 document, he complains to the OUR about whether he should be required to pay the tax in the deposit. At 512 and following, Ms. Sola Hines, on behalf of Cable and Wireless, does an extensive response in which she refers to the special notes, the fact that Cable and Wireless will be required to pay the tax, and in fact, if you look at 514, you will see where she speaks about the fact that the tax will be added to the OUR's approved termination rate, which is information that is obviously coming out of the administration.
Right, I'm sorry. Can you just show us in this document where she says that the tax is payable by Cable and Wireless?
Where are my lord?
I think that's what you said.
Yes, I did. If you find the middle of the page on page 513, and there's a long section where she asks about Lime taking into account its obligations when seeking to determine what should be set up as a guarantee and so on. She comes down to quote the note which says the terminating carrier should pay over the tax in respect of the international call. You see that, my lord, in italics in the middle of the page. A and D.
Terminating, yes.
Yes,
Yes.
right after the quotation from the note.
Yes, yes.
She says, this is her understanding, she says the effect is that for all the
Yes,
international calls,
Yes.
Thank you,
I
my
have it.
lord.
I have it. Thank you.
And that's to OUR, so that's their case to OUR.
This is Cable and Wireless writing to the OUR and copying Mr. Robinson, as we see on 515.
I see. That's Cable and Wireless's case.
That's Cable and Wireless's case.
Yes, I see.
And
Yeah.
And then we have the OUR responding on 516. And what the OUR says, my lords, at 517 in the middle of the page is based on the nature of the contracted services, that is, joining services, Lime would be the terminating carrier. Since Lime is the terminating carrier, it can clearly be seen from the provisions of the note, the technical note, that Lime is the entity liable to pay the call tax over to the tax authority. She then quotes from 28.2, which my learned friend had adverted your lordships to earlier. She then goes on to refer to 9.7 in the interconnection agreement and says, therefore, based on 28.2 and 9.7, the office has determined that it's appropriate to include the call tax in the calculation of the initial deposit. So, although she comes, my lords, at the end of that letter to say it should be included in the deposit, she treats with who should pay the tax. And this occurs before, my lords, the injunction was obtained. In her opinion, who should pay the tax?
Yeah.
So, my lords, having come to that position, I have heard my learned friend say that his client was not bound by this determination. Well, we disagree. He was bound by this determination, by the OUR.
When you say by this determination, do you, what?
The determination of the OUR that it is appropriate that the call tax be included in the initial deposit.
Okay, so what is the basis on which they are bound by this determination? Why are they bound by it?
The provision, my lord, in the interconnect agreement
Okay.
and the OUR Act. But in this case, we had a dispute resolution. That resolution was determined by the OUR in favor of Cable and Wireless.
Well, sorry.
I'm sorry.
You've mentioned two things. You
Yes,
mentioned the OUR Act.
Yes, my lord.
And you've mentioned the agreement.
Yes, my lord.
So, taking the agreement first,
Very well.
could you just show us the provisions which means that this is binding on Traille?
I will, my lord.
36.
If I can take you, my lords, to page 321.
So it's clause 36 you're relying on.
That is the one that I rely on, my lord. Clause 36.7.
Give me one moment. Close that. Resolution. Sorry.
And the previous provision, my lord,
Just give me a moment. So 36.1 provides for the parties to use the following procedures to resolve the dispute.
yes, my lord.
Now, you're not saying that they've followed those procedures.
No, my lord.
You're relying on 36.7, is this right? Sorry, is it?
Yes, my lord.
That's right, is it?
36.7.3.
I see. Nothing herein shall prevent a party, yes, I see, referring the dispute for resolution. I see. A party. Right.
And that's the specific provision relied upon by the Court of Appeal. Is that right, I think?
I believe that the Court of Appeal did mention that, did find accordingly, my lord. I don't have it in front of me here, but I will certainly locate it for your lordship.
That would be helpful, thank you.
But they were entitled, it was Mr. Robinson who referred the issue to the OUR.
Right.
Cable and Wireless made its submission, and at the end of the day, the OUR said, pay the deposit with the tax.
So, sorry, the letter. Could you just show us Mr. Robinson's letter? Is this the letter? Yes, I just want to get this right.
Yes,
Is the letter at page 510, is it? That's the
510,
letter
what is
where
his letter?
he refers the matter
Yes,
to the regulator.
That
Yes,
is
I
it.
see. He heads it dispute and then says that he calls on the regulator to intervene in this dispute.
Yes,
I
my
see.
lord.
I see. Thank you.
And I take it that the implication is of a dispute resolution clause like that it must be there to bind the parties insofar as they go to that dispute through that dispute resolution procedure.
In fact, my lord, I will find the provisions in the OUR Act in the break that once there's a determination by the OUR, it's binding unless you follow some process to set aside that determination.
Okay.
So what we have here is the OUR making a determination on this issue.
Right.
So, having sought the OUR's assistance and having obtained it, he ignores it, we suggest. And not only does he ignore it, my lord, contrary to any view that he accepted what the OUR said, the fact is that he paid no deposit with any tax in it, whether 70 or 30 or 100. He paid none. And in fact, my lord, he only paid that deposit with tax, or rather, the tax portion, after the judgment of my Lord Batts. When he was seeking to proceed to the Court of Appeal to appeal Justice Batts's order, he made an application for a stay to the Court of Appeal. And that, my lord, can be found.
So when you say he didn't accept the decision, I think it was put against you that he did accept the decision to the extent he was willing to pay 70%.
Well, my lord, I am going to take you to the affidavit that Mr. Robinson swore in support of his application for the injunction.
Right.
And when you look in that affidavit, my lord, it's in the supplemental bundle, pages 1457 and following.
So the supplemental.
There's a supplemental bundle, my lord. It
just give me a
starts.
Supplemental.
Supplemental record, I beg your pardon, supplemental.
Okay, it's part of the main record.
It's part of the main record.
Yes, sorry.
So which page are we on in the main bundle?
So I'm referring you, my lords, to,
1457, is it?
it starts at 1457. But I will take you directly to the complaint before my Lord Brown. And that complaint starts on 1461, paragraph 12. 1461, paragraph 12. In that, my lord, he is saying he is willing to comply with the agreement to pay the 3 months security deposit, but he stops there. And if we go over the page to 1462, he complains in paragraph 18, he has a contention with the OUR ruling. So he is challenging the OUR's ruling, not with the OUR as a party to this action, but he says from paragraphs 18 onwards on 1462 that basically he is not supposed to pay the tax. He then goes on to reference a technical note. He recognizes that what the OUR was saying then is that Cable and Wireless is to pay the tax. But he says right in the middle of 22, the claimant is liable to pay tax under this order. OUR admits that the Act provides no further elucidation as to who should pay the tax. He says the Ministry of Finance notes were prior to the gazetted law, and he's therefore worrying what OUR intentions are if the contract is clear on usage charges and the law does not state that the defendant Lime should pay the call tax. So, my lord, what we are saying here is that there can be no doubt that from before the switch was turned on, Mr. Robinson and Traille was well aware that this issue as to who is to pay the call tax and whether it's included in the deposit was alive. It didn't arise in November of 2014. It arose at the time that the injunction was being sought. Or before, actually, it arose before in the dispute resolution procedure with the OUR. And then it was front and center of the application before the court. And my lords, as you will see, the correspondence between the OUR and the parties were exhibited to Mr. Robinson's affidavit. He then goes on in 24 to say the claimant also contends that even if the defendant is to pay the call tax, he's not agreeing, but he's hedging, their calculation is wrong. So, my lords, there was no subsequent new argument that arose after the injunction. This was all within the res gestae of getting the switch turned on. He recites about the 30% exemption. He refers to the Gazette overleaf. And he complains about honoring his international carrier contracts. And he says he must be allowed to operate his business. And he seeks and obtains, my lords, a mandatory order, a mandatory injunction forcing Cable and Wireless to turn on the switch. And he does so without paying any of the tax. So, my lords, as I intend to advance further in our submissions, there can be no doubt that losses flowing as a direct and probable cause of the grant of this order would include those losses flowing from the possible failure at that time of the claimant to honor his obligation. And I would want to take you now to the affidavit of Simone Winter, which
honor his obligation to pay the deposit.
To pay the proper deposit with the tax, my lord.
Yeah. So,
and in fact, not just the deposit, but payments of interconnection charges.
Well,
and
that's what really matters, isn't it? In relation to the cross undertaking.
Absolutely, my lord. And I am taking you to Ms. Simone Winter's affidavit in which she treats with this expressly before the injunction judge.
Yeah. Just managed to squeeze that in before the short adjournment.
My lord?
No, I mean, if you can do it in a couple of
I'll
minutes,
do it. Then, very well, my lord, I will.
Get to the end of this and then...
Yes, my lord. So, my lord, in the affidavit at page 1471 of Simone Winter, it actually starts a little bit before that. It starts at 1467, but at 1471, after referencing the provisions of the interconnection agreement, Ms. Winter sets out in paragraph 15 who the applicable taxpayer is. And all of that is set out there. She deals with service supplier and so on. She then refers to exhibits in which she reminded Mr. Robinson of the need to establish a guarantee and adverted his attention to the Bank of Jamaica website for a list of approved banks. She refers to the fact that she hadn't included transit charges. She recalculated those. And then, my lord, it goes on where in paragraph 18 she refers to the interchange between the parties and the OUR, and she refers to the exhibits exhibited by Mr. Robinson. And then, my lord, when we get around to, I will leave your lordships to read the parts between 19 and 20. In 21, I state that Lime must comply with the dictates of the tax collecting order, and it will be required to pay the tax to the Commissioner of Taxes on overseas traffic terminated on its network, even if the tax is not paid over by the claimant when paying the usage charges. Accordingly, the deposit seeks to reduce Lime's potential exposure, which is substantial, and as is evident, could easily amount to nearly $10 million within 3 months if the claimant terminates the anticipated traffic, and terminates anticipated traffic, meaning sending the traffic, my lords, and then fails or refuses to pay the tax. This is exactly what he did. Lime has no information as to the extent of the claimant's investments or assets, save as to the cost of interconnecting with Lime, but the claimant is a recently incorporated entity, which at this stage is apparently unable to deposit 3 months' potential tax liability. Further, it is the claimant who ought to, but has failed to provide this honourable court with an indication of the value of assets owned by the claimant, if any, which would satisfy an undertaking in damages, not just costs, as required. Accordingly, in these circumstances, Lime is of the view that this honourable court ought not to grant the claimant a mandatory injunction to force Lime to provide the service sought without the claimant fulfilling its contractual obligations under the interconnection agreement to provide a bank guarantee for the entire security deposit now due, thus exposing Lime to real and present harm without the requisite deposit in place. And then she goes on in 22 to deal with something further.
Well, that does take us up to the time.
Can I just, while it's open, could I just ask one question, if I may, on this, just to clarify something? On page 1472 in the affidavit we're just looking at, paragraph 17,
yes, madam.
She refers to an email to Mr. Robinson dated the 10th of April 2014 and said that accordingly the deposit was in fact $83,479 odd US dollars.
Yes, my lord.
Now that figure included, that 83,000 included the estimated call tax as well.
Yes, my lord.
At 100%.
That is so, my lord.
All right, and that's the if you like the specification of the initial deposit on which Cable and Wireless relied.
That is so, my lord.
Thank you very much. Thank you.
Very well.